So good afternoon, and for those who are in different time zones, maybe good evening. My name is Daniela Caruso. I am the director of the Center for the Study of Europe here at Boston University. Now, this is one of the regional centers hosted by the BU Pardee School of Global Studies. Today, it is my pleasure to host Dr. Ioannis Kalpouzos, who is here to present his work and discuss it with our panelists and all the participants. I'll start with a few words about him and about the panelists. Dr. Kalpouzos joined the BU community in the fall of 2020 as a visiting assistant professor. He is on leave from City Law School, University of London, where he is a faculty member. He received his LLB at the National and Kapodistrian University of Athens and his PhD from the University of Nottingham in the United Kingdom. His scholarly interests include international human rights, international criminal law, the legal concept of war applied to situations in which non-state armed groups are involved, and the law of new weapon technologies. Most relevant to today's discussion, Dr. Kalpouzos is co-founder of the Global Legal Action Network, GLAN, a collaboration between legal academics, practitioners, and journalists pursuing innovative transnational legal action. He has led GLAN's work in matters of war and occupation, environmental justice, supply chains and accountability, as well as migration and border violence. Among his latest publications is the article International Criminal Law and the Violence Against Migrants. We look forward to hearing about his path-breaking work. As a discussant, we have Dr. Zinaida Miller. Thank you for joining us. Dr. Miller is Assistant Professor of International Law and Human Rights at the School of Diplomacy and International Relations of Seton Hall University. She received a PhD from the Fletcher School at Tufts University and a JD from Harvard Law School. At Seton Hall, Professor Miller teaches courses in human rights law and policy and international criminal law. Her scholarship pertains to legal accountability in relation to old racial and ethnic inequalities, as well as to new conflicts and atrocities. Among her latest publications is an article titled The Injustices of Time, Rights, Redistribution, Race, and Responsibility, and also a co-edited collection titled Anti-Impunity and the Human Rights Agenda. Dr. Dimitros Skiadas, also our discussant today, currently is a visiting researcher here at the Center for the Study of Europe. Welcome, Professor Skiadas. He is professor of Jean Monnet Chair at the Department of International and European Studies of the University of Macedonia in Thessaloniki. He received his Bachelor of Laws at the National and Kapodistrian, maybe I made a mistake. Okay, Kapodistrian University of Athens, and his PhD in European law at the University of Durham in the United Kingdom. His scholarly interests concern the governance of the European Union with an emphasis on its economic and social policies. Among his recent publications is the book chapter EU Budget and Migration, the Value for Money Quest. He is currently working and lecturing on the topic, the interaction between the EU budget and the EU social rights pillar. I am delighted to give the floor to Professor Ioannis Kalpouzos.
Thank you very much, Professor Caruso. And as warned, I will be sharing now my screen, which will include a presentation. Everybody can see it? Wonderful. So I'm very grateful, and everybody can see me as well, by the way? Yes. Okay, so I'm very grateful to be joining you, and I'm very grateful to be having this opportunity to talk about our work at the Global Legal Action Network. What I'll try to do today is start by introducing the idea behind the setting up of this organization and the idea about trying to create a academic and practitioner organization which engages international law and international human rights in the broader sense in a way that is critical. And then look at some of our cases, try to present some of our cases, some of examples from 3 of the 4 themes that we work on. And it will be quite a bit of material. Some of it will be discussed in a little bit more detail. Some of it will be mentioned, and I would be very happy to continue commenting on it at Q&A. And so I have a couple of caveats. One is that a lot of the work that I will be discussing, in fact, all of the work that I will be discussing is conducted and developed along my colleagues. Some of it, in fact, is led by my colleagues. And in many cases, I will be mentioning their names, but I just want to say as a default that while some of this work also relates to my scholarship, some of this work I am actively and directly involved in, it is all collaborative work. The second caveat is, which I think follows from the first, is that even though I will try to present to some extent, cohesive understanding and cohesive view of the type of work that we do, fundamentally, I would not attempt to exaggerate, right? Both the cohesion and also necessarily the agreement among all parties in GLAN, in the Global Legal Action Network. There are disagreements, there are different attempts, there are different approaches. In a way, neither I nor we collectively have the answers to the questions that I will try to pose today. And I do hope that the conversation with the distinguished discussants, as well with the audience in the Q&A, will help me also reflect on some of this practice. So I want to start with a phrase that in a previous presentation a couple of years ago that I did with my colleague and the current executive director of GLAN, Gorodo Quinn. He had prepared some slides, and he had started with this phrase: "I want to use international law to challenge international injustice." And when I saw this phrase, I had a bit of a reaction, which was, what is this? What are we doing? Do we want to really speak at this register of earnestness, of, to some extent, naivete, that our work will actually and practically challenge international injustice? This is something, and this is a kind of statement that makes me a little bit uneasy, uncomfortable. And then I thought better of it, and I thought that, in fact, this discomfort that this particular type of statement is good, is important, because it captures two things. One, it captures a kind of, again, naivete, I suppose, or impetus that we all have or had, or to some extent still maintain in our engagement with these issues, in our engagement with these norms, in our engagement with these institutions, even after, through our intellectual, scholarly, or practical sophistication, we realize that this sentence is in dire need of multiple qualifications. And secondly, that indeed a feeling of discomfort and frustration is fundamental and important when one engages with international law on both sides, both in terms of challenging the idea that you're doing good, but also challenging some easy, as it were, cynicism and a stance that international law is fundamentally part of the problem and there's nothing that you can do about it. So it's fair to say then that GLAN is something that came from two frustrations. One is a frustration with the law, frustration with the contents of the law, frustration with the application of the law, frustration with the realization that in many ways and in many areas, law is part of the problem, as well as occasionally a frustration with the law, as it is experienced in myself, as well as it is experienced in many critical spaces where the realization that the law is part of the problem is too often, sometimes, the end of the conversation. So the idea is, how do you mobilize, how do you engage, how you develop these insights, this type of sophistication, intellectual, scholarly, practical, political, in order to engage international law critically and human rights critically? And I guess there are two aspects in that. One is, how does one create an organization which combines critical insights from academics and from practitioners? How does one identify the type of contributions and the type of critical insights that academics and practitioners bring to the table, and that may be in great discussion and conversation, or might be slightly different, slightly separate. How do you also mobilize non-legal expertise, non-legal critical insights, as you will see, especially from areas such as journalism, specifically investigatory journalism, the role of technology, in order to both practically aid, but also help develop insights on the type of interventions that will have the greatest effect. And fundamentally, and this is a problem that, not a problem, but a question that any organization that functions transnationally or internationally in Europe or elsewhere needs to engage with. How do you relate to local insight and agency in terms of not only informing, but also fundamentally guiding your action? And these are factors and elements that inform every single action and every single project that we have undertaken, and that I hope that I will have the opportunity to highlight in some of the discussions of the specific cases and the specific themes that that I am going to be presenting to you. And then from a more practical, but equally, I think, important in substantive and even potentially ultimately normative terms, is the idea of setting up a practice, that coming from academia, connecting with practitioners and developing the type of practice, in my case, from an academic point of view, that mobilizes the research, the expertise that academics and practitioners have in a particular direction. And something that I would also be happy to discuss more in the Q&A, how does one negotiate the balance between having a more or less network, right, which is decentralized and which allows and defers to the choices and the decisions and the ideas and the creativity of our members and our experts, and to what extent do you also try to impose a cohesive vision? And I will try to some extent articulate some elements of cohesion from a conceptual perspective today, but in practice it is of course another matter. And also, as one goes along, how does one seek and find the funds for said practice? To what extent does one operate from within an institution that one is a part of, and specifically an academic institution? And to what extent one tries to become an independent organization and seek funding and therefore develop a certain practice and rhetoric that brings us in contact with those that provide funding, such institutions. But also, since I am primarily first an academic, how does one engage both one's research, but also one's teaching in the application and the development of practices, within an organization? And that is something that, again, as you will see, will feature in a lot of the themes, both in relation to different types of practices of clinical education and in relation to activation of research, either my own research or the cultivation of research projects, students, and so on and so forth in this context. And this is the type of structure that these considerations, if you will, led to. The particular form or shape is not deliberate. I don't mean to suggest any religious or martyrological connotations here, or that our executive director is at the very heart of this martyrdom, or indeed that our volunteers and interns are the feet of the organization. But it does show, I think, to some extent, the balance between a core center, the director and the executive team who work full-time, as well as the Legal Action Committee, which is a committee that combines academics, practitioners, and in some cases, investigatory journalists, the advisory board, which provides, in some cases, advice and guidance, the Board of Trustees, which professionalizes to some extent the practices of the organization. And here is another important point to discuss: the degree of professionalization and how it interacts with trying to do critical work. And our contacts, other organization, partner organization, journalists, volunteers, interns, and so on and so forth. The second question in developing a critical academic practitioner organization is perhaps more substantive. How do we do critical international law? How do we do critical international law when we start from the understanding that both the rules and the structures of the international legal system, both historically and at present, quite clearly benefit the most powerful actors? It's the way that states have created public international law. It is the way that a Eurocentric historical evolution of international law is clearly reflected in both the content and the application of all legal regimes, including those regimes that have ostensibly a more humanitarian and protective character, like human rights law or like the law of war. And in engaging this reality, investigating to what extent rules, concepts, institutions, jurisdictional angles could be employed, engaged, both to highlight those degrees of asymmetries and injustices, but also in some cases potentially challenge the structural injustice, challenge in increasing the cost of certain actors, challenge in terms of presenting certain legal, practical, political, rhetorical, expressive counters to the activities and to the actors of in particular instances. Challenge, if you will, it might be a little bit sort of facile to use this parallel, but perhaps on some level in a slightly guerrilla fashion, right? Of engaging a regime and a system which is quite clearly set in a particular direction. And in that process, identify what kind of interventions, which include litigation, which include the engagement of specific institutions for litigation, whether they are courts or whether they are quasi-judicial institutions or whether they are slightly more soft law mechanism. And I will give you examples in that context, serve such purposes. And indeed, today I will give a number of examples, some of which might be Europe focused. I think that perhaps the majority of the talk will be in discussing the engagement of Europe focused institutions, partly because, well, of the title of the talk and of the focus of the center, but also partly because of the way in which we have operated and the development of our actions in practice, which again, I would like to stress, do not follow a predetermined, right, cohesive strategy. Which brings me to the final, as it were, point that a certain ambivalence towards the idea of strategy or the idea of strategic litigation as a whole, perhaps in two ways. One is to the extent that it suggests that there is a clear and long-term strategy with respect to what we do. And secondly, that especially when we are discussing cases that relate to specific applicants, that it relativizes the importance of the specific applicants and their interest in specific cases. But also speaking to a slightly broader question of, and I will not expand on this, but on, the extent to which one can have a strategy in relation to the evolution of a complex system, absent a particularly, strongly articulated final goal. To what extent are we in our actions adjusting to the vicissitudes of an imploding system, and to what extent are our interventions, I wouldn't say opportunistic, but in any case, not really having an overall and a clear strategy in that respect. I'll leave this open. So that impetus led to choosing to engage with specific themes. To some extent, the engagement with these particular themes was organic or inductive. It was the result of the activation or the mobilization of the research, my research, as well as the research of the co-founders and the members of the organization as the organization developed. But they did they did tend to touch on A, specific themes and topics, and B, in a particular way. And that is in what I really want to talk about for the rest of the talk today. To what extent war and occupation, environmental and economic justice, accountability and supply chains, migration and border violence are not only important with respect to the phenomena that they describe, the type of, if you will, injustice or effect that these issues and these themes may have on individuals' lives, but also to what extent they might reflect questions of structural injustice and to what extent you can address them in the way that speaks to those questions of structural injustice and inequality. And to what extent can you use legal concepts and legal regimes in order to do so? So, starting with environmental and economic justice, I will focus mostly on one case. And it is one case that some of you may be familiar with. It is our application before the European Court of Human Rights against 33 states, members of the Council of Europe, in relation to climate change on behalf of Portuguese children. And you can see here the children, as you can see, comparing the picture on the right to the picture on the left. One of them, André, has grown quite significantly. So in 2017, as you may remember, there were significant wildfires in Portugal that affected the lives of a great number of people. And at the time we were just starting up as an organization, and we had a researcher who at the time was doing a PhD at King's College in London, and who was Portuguese, and who was in contact with people in Portugal who were interested in doing something, and were interested in articulating both what happened, but also what they feared and they knew would happen in the future in human rights terms. And these were and are the 6 claimants that you see in this slide, who are the applicants in the case at the European Court of Human Rights, which was submitted in 2020, in April 2020. Arguing that the failure of the states of the Council of Europe to decrease their emissions and their contribution to climate change beyond a specific degree will lead on a causal pattern to the violation of the rights of individuals, and specifically to the violation of the rights of children. So it is a complex case, and it is a complex argument, partly due to the fact that it is against 33 states, partly because of the nature of the responsibility and the way of addressing this responsibility. And I just want to highlight certain elements of this case, and perhaps I will try to highlight these elements of the case in the way that I think expresses why it is important from a structural perspective. But the starting point is, of course, the urgency. And the urgency speaks to the necessity of engaging the international and, in another way understood, the transnational in this context, not instead of, but alongside and in support of the domestic. And that urgency also relates to the use of the language of human rights, which is a language that is sometimes perhaps too easily used or too uncritically used, but which we argue is meaningfully and accurately used in this context, because also it helps concretize and specify the consequences of what is happening. the consequences on specific rights, the consequences on specific rights in the present, but also in the future in a way that is causally demonstrable through the science and the scientific partners that are aiding us in this particular case. And therefore also the nature in legal terms of the claimants as victims in this context. And the fact that this is not a case which is an actio popularis, or a case which uses the specific individuals in order to make a broader strategic point. But it is a case that is very much about them. So the use of human rights law works in order to concretize and specify the danger of climate change, right? And the role and effects and consequences of climate change. And we think that that is an important critical intervention in this context. Secondly, and conversely, if you will, one of the main issues, as we know, and difficulties of addressing climate change is the nature of the contributions to climate change, and therefore the nature of the responsibility to climate change. And here, again, our legal argument, we hope, and this is perhaps one of the most complex parts of this case, helps address both the way in which shared responsibility should work in this instance, and the way in which shared contribution has traditionally worked in favor of relatively more powerful actors. So we articulate state responsibility in this instance as shared, but also we articulate it as presumed. So the idea is that to the extent that all states contribute to the ultimate indivisible injury, there is the presumption that they are contributing to the degree of increase of the temperature which is beyond the legal obligations in accordance with international law, and therefore unlawful as a matter of human rights law. And it is for the court to agree and declare that, and for the states to extricate themselves from that responsibility. So the shift of the presumption is shifted in this way. And in fact, that the ambiguity with respect to that responsibility should weigh in favor of the applicants, which is in fact an application of a general rule of both domestic and international law when it comes to the share of responsibility. But also that the margin of appreciation, which is, as many of you know, a legal doctrine that the European Court of Human Rights has developed to defer to some extent on local knowledge and local conditions. In this instance, and despite some of the environmental jurisprudence of the court, should be interpreted and applied as narrow and should not allow for undue deference to states in the determination of their nationally determined contributions. And that also, as it were, bridges over to an articulation of a type of jurisdiction, which brings in the transnational element of the contribution to climate change, at least within the context of the espace juridique, the legal space of the Council of Europe. And indeed, and again, I will not expand on this, but we hope also that this might be an intervention in an evolution of the law and jurisdiction at the European Court of Human Rights, which is both complex and quite problematic and seems to be increasingly and erroneously focusing on particular understandings of control, either territorial control or personal control, but in fact, also relates and includes a tradition of responsibility of acts that are committed both territorially and extraterritorially, and that have consequences both in the territory of a state and in the territory of another state. And finally, the idea of going to the European Court of Human Rights without first going to each and every domestic court, despite prima facie the obligation to exhaust domestic remedies, because of the very urgency of the situation, because of the fact that even if domestic courts of each state are able, like the one important case that we have, the Urgenda case in the Netherlands, to address the contribution of all of these states. The timeline is unworkable, and indeed our claimants do not have the means to do that, as in fact the jurisprudence of the European Court of Human Rights supports. So the case as a whole aims to articulate urgency, articulate a notion of shared responsibility that highlights the responsibility of the relatively more powerful actors, and that weighs in favor of those suffering from the consequences of the acts of the more powerful actors. And that is both, I think, relating to the inherent features of the structural consequences of environmental harm and climate change that have so many other applications and such a rich and developed area of law, but also we think and we hope in the way that we engage and activate human rights law in this instance. The case has been submitted to the court and was communicated by the court to the 33 states. So it crossed the first initial single judge level of admissibility. And in fact, the judge asked the states to respond not only to the rights of life and family life that we included in our application, but also to the question of potential violation of the prohibition of causing inhuman and degrading suffering, which in one way concretizes and articulates the harm even further from what we did. The French decision in front of you. And secondly, then the states responded. Also, the court importantly accepted our argument for urgency. The states responded asking a separate discussion of admissibility from merits, as well as more time. The court declined their request for a separate discussion of admissibility from merits, did allow 16 further weeks. You can see at the very bottom of the letter of the court to the states. Actually, this is a letter to us, which relates what the court said to the states. And we are awaiting the receipt of the responses of all 33 states. We have managed to hire a number of legal researchers that are going to be working full time on this, because once the court communicated the case to the states, some funders saw that this is an important case and decided to help us in this direction. Primarily, by the way, the funding of this case was through crowdfunding. And we are actively working on this case. So I will not discuss in detail other cases in this area, perhaps only to mention that we also engaged in some contribution to drafting. Some of our members are Irish, and there's nothing wrong with that. And we contributed to the drafting of an Irish bill in Parliament, which led to the divestment from fossil fuels. And we have also, a lot of them recently, because this is a theme that we have been developing, especially in the last year, contributed to cases that have to do both with environmental and economic justice in terms of land grabs and the Wetland Convention, in terms of rights of the child and tax avoidance, and in terms of addressing the OECD with respect to mining in Colombia. But I want to move to the next theme, which is migration and border violence. And here there are two angles that I want to present to you. The first one is the activation of a legal regime which is not usually employed and is not usually envisaged in the addressing of how states how states regulate migration. In a way that can be seen as provocative, but we believe is doctrinally justified, and also does some normative work in terms of at least expressing, if not addressing, the nature of the violence. So following some scholarly work that myself and a colleague called Itamar Man did in the context of detention of asylum seekers in Greece. But today I will try to say as little bad as possible about Greece, as it is the bicentennial of the Greek Revolution. So, you know, I will try to be good in that respect. We worked with Stanford Law School and the clinic at Stanford Law School, International Human Rights and Conflict Resolution Clinic. It was at a time when there had been a recent leak with respect to Australia's policy of offshore detention in Manus Island and Nauru. And Stanford were also able to send a number of students as part of the clinical program to interview detainees that were being moved to Australia for medical care with respect to the conditions of detention. And we applied international criminal law, and we applied specifically the concept and the category of crimes against humanity, which prohibits specific acts, including unlawful imprisonment, unlawful deportation, persecution, to the extent that it's part of an overall widespread or systematic attack against the civilian population. And the law says that the definition of an attack is indeed a course of conduct that will include the commission of these prohibited acts. And that was partly because the law fit, we thought. It was also partly because we had been engaged in a conversation about international criminal law, about how international criminal law predominantly focuses on weaker actors, how the International Criminal Court specifically predominantly focuses on investigations and trials in Africa and has for that purpose been considered to be a new colonial tool, and the extent to which international criminal law could address acts by relatively powerful states, which are not spectacular in the type of violence that they perpetrate, but which fit within the definitions of international criminal law, and also relate to and speak to some of the issues of structural injustice that are, in fact, of course, involved in both migration and in the treatment of migration. So as you see, the particular also strategy, if you will, or tactic that we followed in this instance was submitting the communication to the International Criminal Court in the name of a number of academics who are experts in international criminal law worldwide, including one of them in Australia, and who all either contributed to or, of course, read our communication. So it took, by the way, the court 3 years to respond. Eventually it responded, and it conceded that the detention did fit the definition of unlawful detention for the purposes of the Rome Statute, its treaty. But it did a funny interpretation where, so that the primary criterion for unlawful detention is its arbitrariness. And indeed, in the case of Australia, there was arbitrariness in terms of the review, and there was arbitrariness in the fact that the detention was effectively open-ended. The average was, I think, 454 days. But the court focused on the inhumanity or the conditions of the detention, and it therefore allowed it to articulate it in a way of saying that the camps were created, somehow the conditions became inhumane, and Australia failed to do something to stop them being inhumane. But Australia's failure was not an actual encouragement of an overall attack, which I think is wrong on both the facts and the law. And indeed, we are working with local actors. I mean, we worked with local actors before, but also now a new set of local actors in terms of following up on this particular issue. The second aspect of migration that I want to briefly touch on is in relation to the European Court of Human Rights, as well as other human rights bodies, as well as bodies that are not traditionally human rights bodies. And in this instance, if you will, the overall impetus concept is diagnosing that the way the global north, including Europe, including Australia, including the United States, deals with the migration crisis is through what has been observed as migration externalization and the creation of distance. And what are the tools and the techniques to travel that distance back, right? One such tool and technique might be, again, in the interpretation of the European Court of Human Rights concept of jurisdiction, and therefore the extraterritorial application of human rights. And in our case, SS versus Italy, which you can see the Guardian news story on the top, we argued that the relationship that the Italian state has with the Libyan Coast Guard, both in material terms, in terms of funding, in terms of training, in actual ongoing terms, in terms of communication, guidance in their operations, amounts to effective control, which does not require the actual physical control of Italian agents over the migrants that are pulled back in Libya by the Libyan Coast Guard, and therefore subjected to human rights violations in this context. The case also has been communicated to states and is pending before the European Court of Human Rights. Another case which might also interest especially one of our discussants, Professor Skiadas, is addressing the EU Court of Auditors, which is a body that controls the budget and the application of the budget of the European Union, and it is not a human rights body, arguing, and this is a complaint and a project which is headed by my colleague Valentina Azarova, argue that the EU's financial aid to Libya, which contributes to the maintenance of both camps, but also the capacity of the Libyan Coast Guard to pull back migrants, is not properly defined as development aid, but it's more security and border security, serves border security purposes, and B, contributes to human rights violations, and therefore the Commission should be held accountable through the EU Court of Auditors. We understand that it's a relatively novel use of the EU Court of Auditors. Again, the EU Court of Auditors is considering this case. We also, working alongside Italian organizations, followed this up with a petition to the European Parliament, which we understand has been and will continue to be discussed on some level. And that is a set of, if you will, activation of concepts, institutions, jurisdictional angles that aims to specifically target the question of the creation of distance and externalization of migration control. As my time is running out, I want to very briefly highlight two, again, types of engagements with the theme of war and occupation. The first one might seem a little different to what we have been discussing before. It has to do with targeting, and it has to do with engaging journalists, investigative journalists, as well as specifically an emerging community of open source investigators, some of whom, by the way, have also helped us in our migration work. Forensic Architecture, for example, is working with us on migration work that we do in the context of Greece, in order to investigate targeting, and in order to help the analysis, the application of international humanitarian law and international criminal law when it comes to the applications of the principles of distinction and proportionality in the context of targeting. And this started with a hackathon, which at the time I thought it was quite cool that I was participating in something called a hackathon, which involved bringing in investigators from the New York Times, from Bellingcat, from Channel 4 in the UK, as well as other investigators to London, again at King's College, and doing a 4-day hackathon, where after a first day where we discussed questions of law, evidence, and so on, they looked at a series of airstrikes in the context of the war in Yemen, conducted by the Saudi-led coalition and analyzed them from a factual perspective, identifying what, who, where, when, identifying the specific elements of what occurred, and leading to a dedicated website, which you can find if you Google the Yemen project, which sets out an analysis of these types of investigation and airstrikes. Now, why is that in any way, critical? It is because the law of armed conflicts and international humanitarian law is guided by a particular epistemology, a particular way of knowing things, which differs A, to the mind of the commander, B, to more professionalized and militarily and technologically developed states. And indeed, the effort to find violations of international humanitarian law is in many ways an uphill struggle against the structural advantage that the more advanced parties have. And that practical analysis led also to a clinical project which started between me and the group of students at Harvard Law School and is now aided by an excellent student here at BU, which tries to identify how open source analysis and investigation contribute to the analysis of international humanitarian law and targeting, which is both, if you will, a scholarly perspective, but it is also a practical perspective, which also speaks to epistemology, but also speaks to the empowering of investigators and the empowering of actors seeking accountability, and which also is leading to our development of a particular digital evidence vault, a database of specific incidents that will also be made available to any users in the context of potential accountability projects, which is still currently in development. We're kind of in the middle, if you will, in that chart. And my apologies for going a little bit quickly. But also have already contributed to some litigation, contributing alongside an organization called Muatana, which is an important Yemeni organization, to a follow-up from a UK decision in relation to the legality of arms sales by the UK government to the Saudi-led coalition, as well as other domestic cases that we are currently undertaking and will release when we are ready to release. Finally, and to conclude, the other aspect of engaging war and occupation is indeed occupation, but it is also occupation in a way that speaks specifically to the exploitation of situations of occupation by third parties, especially powerful either state or corporate parties. A corporate element, by the way, was also present in our application to the International Criminal Court in relation to Australia, as these camps were run by private corporations, and which aims to both engage bodies that are not usually engaged in this context. So I was personally involved in an application to the OECD, the Organization for Economic Development in Europe, their national contact point in Ireland, a soft law mechanism which provides recommendations for corporations in to the extent to which they seem to be going against specific human rights in the effects of their corporation of their practice, specifically in relation to a Irish corporation called San Leon and their plans to drill off the coast of Western Sahara, as well as engaging other unusual, if you will, fora with respect to corporate involvement in Western Sahara, like Messe Berlin, which was a marketing, and a set of a food logistics trade show, right? not your usual practice, as well as reports and practice in relation to business and human rights and the involvement of corporations in situations of occupation. As I said, these are not necessarily either providing a cohesive conceptual overview or necessarily showing an overall strategy, but they are ways in which we have tried to do international law in a way that is goes against, right, the structural biases which are built into the system and which addresses questions of inequality, questions of injustices that go at some depth. So I am about 6 minutes over time, and I apologize for that. And I will happily stop sharing my slides and yield my time to my discussants.
Thank you so much, Ioannis. This was a tour de force, and I look forward to you being debated by our discussants, and I look forward to opening it up. And I will remind the audience that in the chat, the first message in the chat is a reminder that after 6 p.m., Professor Kalpouzos will be available for a Q&A session led by the International Law Society of Boston University, our wonderful students. Professor Miller, would you please start?
Hi. Thank you so much, Ioannis. That was fantastic. And thank you, Daniela and Elizabeth, for having me and giving me a chance to speak here. That was a lot. My main challenge now is going to be trying to read my handwriting from the notes that I just took on top of what I was thinking about earlier. So we'll see how that goes. I have a few points. Essentially, they're themes that emerge for me throughout your talk, Ioannis, and I know many of them are, in fact, themes that you have played with and thought about in your work. So in a lot of ways, these are prompts to pull out some of the points that I think are underpinning a lot of the ideas that you put in place there in your talk. So I'll just essentially run through 3 or 4 that I think emerge from the kind of work that the network is doing and how interesting it is to take on this project, essentially taking it from the aspect of what does it mean to do critical international law and critical human rights work? So the kind of beginning prompt that you had, and I'll mention some of the specifics, but I'm gonna kind of try to take it from the broader thematic edge a little bit. So the first is really getting at the theme that arced throughout your talk, I think, which is the premise and the challenge of thinking about structural problems and sort of seeing the promise of these forms of litigation, these forms of legal action, and then their limitations, right? So on the one hand, the kind of expressive function, the normative and discursive actions that can take place, along with any material or punitive returns that might take place from any of these different projects. Litigation in particular, we know, is a very powerful legal tool, right? It's sort of, you know, the thing that always goes at the top of the hierarchy in a lot of ways. And we have this kind of the notion of mobilizing legal expertise and kind of the capacity of lawyers in all of those ways. And I think the interesting doctrinal moves that you're articulating, and I'll come back to those, about how using the doctrine against itself in some fashion, right? So finding essentially the loopholes and places where, despite what we see as a not an immovable, but a very fixed set of structures and dynamics in terms of hierarchies, inequalities, in racialized and colonial and other forms, that they can be challenged in these ways. But, right, as I think comes up in some of your talk here, and I know the background writing that has gone along with it, is the idea that the litigation itself comes with its own preoccupations, right? So whether it's a focus on the individual perpetrator in criminal law, whether it's a main, although not only now, focus, of course, on the state and human rights, that particularly when you're entering into litigation, you know, thinking through that kind of cost benefit, right? So the benefit of challenging these structures through their own doctrinal mechanisms, and then the kind of limitations that come with that. And I would think of that not only in terms of the who, right? So the individual or the state, or how to get at an actor that is less familiarly caught in these kinds of cases, but also things like establishing causal chains, right? So on the one hand, the sort of really fascinating, I think, capacities that you're expressing in the work that you've all been doing that have allowed you to, you know, make clear and evident responsibility and victimhood, right, in the climate case and in migration in places that it's often been hidden precisely by the structural aspect. But in establishing that causal chain, there are a number of steps that have to be done as a lawyer, right? That where you have to be able to knit it together, and that in itself, right, can sometimes narrow down how we're thinking about these ideas about responsibility. And in that sense, counteracts the expressivism that you're attempting to achieve, right? So you have the expressive force of the law, and then the question of what it is expressing, and the ways in which the doctrinal or causal formulation might limit how that expression comes out in the particular form of litigation. So that's sort of point one. I won't spend so much time on all of them. Point two is a classic one from international criminal law, and I happen to know that you've thought about it because you mentioned it in your recent article that I recommend everyone read if you have not already. But this is the sort of legitimation function in international criminal law. So I would be curious to hear you speak a little bit about, in particular, when it comes to the ICC, right? That's such a kind of nexus point in which we acknowledge and see the really, potentially, not always, but potentially or arguably toxic effects of the focus through the International Criminal Court. And I know you were speaking about sort of the offsetting effects that focusing in on something like migration, and I agree, it's a creative and fascinating way to think in that way about, again, responsibility and perpetratorhood, to understand these migration systems in a form that I think really does invert and turn on its head many of those prejudices and preoccupations of international criminal law. But it comes along again with the idea that you're very much in that one, right? It's the most direct sort of, I am going to engage with this court and this system of which, I might share many of the worries that I'm legitimating that this is the way in which we seek justice, is to do international criminal law. And so the question of how you think about, how it works to be part of international criminal law itself, and I think that in that way is, I imagine, has a similar, right, there is a similar critique in human rights, and one could raise some similar ideas, but I think it's a stronger and narrower critique in the criminal law world than it is about going to the European Court of Human Rights, where I think certainly there's concern about channeling everything into a case and worrying that you get the right. And so thus, because you have won the case, you've gotten the, material or structural change that should come with getting the right. But actually, it turns out that that's not really what happened. You just won the case, which is not a just, but in terms of those other effects, it might be. So those kinds of legitimation effects and kind of rights ideas. So, one about litigation in particular, two about legitimation. The third is I essentially want to juxtapose what I think of as the displacement problem and the amplification benefit. So displacement would be the sort of, the kind of common understanding that, let's say, we might displace attention, right? So in the choice of litigation, or in the choice of legal action, or in the choice of area, how do you think about the relationship of those choices to the possibility that it's displacing attention from another? And that might be in terms of the strategy, litigation versus not, so it might be that, or it might be kind of areas themselves. Although I think it's clear from the sort of breadth of the topics that in particular you were talking about today, how much can be not displaced. So I think it's also very much about what can be done through that. I'll come to that in a moment. And it also, of course, can be a displacing resources question. So, I mean, on the one hand, I think the sort of whole project of, as you said, the nuts and bolts of putting something like this together, right, where you are thinking about donors, you are thinking about funding. These are really complex, right, NGO and movement questions. And it's always, I think, a question for all of us about when resources go toward one strategy, what are we missing from another? So, again, it's a prompt to, because I know you've thought about it, to ask you to talk a little bit about it. And then the flip, which would be, it's not a pure flip, but we could think that if on the one hand we have the idea of displacement, the other would be the power of essentially amplification in the work of strategic human rights litigation in particular. So that could be amplification in terms of, for example, in your final example, I was thinking about the sort of, the notion that kind of less advanced countries in the laws of war and the ways in which they're not, centered in the law. And so the project can be to sort of use technology and journalistic functions to amplify a different set of experiences in that way. And also, right, a series of voices and causes that are essentially being amplified in this way through the work of strategic legal action, right? And through the work of strategic human rights advocacy. And in that way, the idea would be it's really about either, you know, and I'm not sure how you would think about this, but it could be, I imagine, either scaffolding, so you're creating foundations for further political action, and or about sort of spreading. So in other words, that it's, you know, on the one hand, it's creating kind of legitimating foundations through litigation and other action on which political action can be built. And the other would be a kind of spreading amplification in the sense of catching up disparate experiences or more localized harms into a transnational or international effort. And so my last point on that one, I think, was just to really ask if it's possible to hear more about the, you know, the civil society or community aspect of how you think about this work. You know, it's one that right now, I'll just, you know, pull an example that's very kind of, it's tangential to what you're talking about, but it's in the US right now where something that I'm really thinking about a lot, which is that there is a kind of growing set of advocacy movements around the idea that there should be some kind of form of transitional justice in the US around racial justice. And the tension that's happening, right, is that there have been many local community-led restorative justice and reparations movements for a very long time that may or may not have thought of themselves as anything connected to some transnational idea about justice that has been morphing around for a couple of decades in many different ways. And so there's something maybe to be gained by tapping into that kind of transnational set of ideas, but there's also a real worry right now among people talking about this that, you know, you could have imposition rather than conversation or scaffolding and support. So, you know, from your perspective and the work that you're doing, I think I'm really interested in, you know, that sort of question about who the people are, right? Who are the individuals? So, you know, you have the applicants in the Youth for Justice case, and, you know, in a number of these others where, you know, sort of my question about how you think about civil society and social movement organizing in relationship to these particular avenues of human rights advocacy and litigation. And just finally, thanks again. It was so fascinating, and I'm so glad I got to talk a little bit about it with you and to get to hear your talk. So I'll leave it there.
Thank you so much, Zina, for the very rich questions. Professor Skiadas.
Well, thank you very much. Thank you very much, Ioannis, for a very detailed and extensive presentation of your work and your colleagues' work, as you said. It's a very interesting approach on such delicate issues, I might add. Of course, I have some notes here, and some of the points I wanted to make, Professor Miller has already touched upon, so I will not repeat some of them. For instance, the thing that the issue that this sort of legal analysis may be used as a basis for further political action. So something, I believe that this is something very crucial. However, I would like to just highlight a couple of issues that refer to some of the cases that you identified as indicative of your work, and this is quite interesting actually. The first one, and that has to do also with the jurisdictions that these cases are brought in. For instance, the first case, which refers to the climate change issue from Portugal, and you highlighted the fact that you bring an action against 33 states, from what I remember, bringing an action before the European Court of Human Rights against 33 states is a challenge, a Herculean challenge, I may say. And one of the issues that I would like to ask you actually is, how do you plan to overcome the infamous condition of exhausting all domestic courts before taking the case before the European Court of Justice? 33 jurisdictions involved. So that is a challenge. I don't know how much time we will get or how you will surpass that. And I believe that the member states will first point that out. I don't know what will happen. But that will be an interesting point to discuss, because the Human Court of Human Rights is, at least from my understanding, very keen on examining such issues. Now, with regard to migration case that you referred to, and especially the case where the European Union provides support to Libya and the Libyan Coast Guard, and whether this financial support may constitute an element of widespread or systemic attack in terms of the international criminal law approach, the one that you have extensively analyzed in your papers, and I have studied them carefully, I have to admit, in order to prepare myself for this lecture. I have to say that, first of all, this support, because you said that you brought an action before the European Court of Auditors and you asked them to oversee, to examine whether the European Commission may be held accountable for that. The problem is that the European Commission will never be held accountable for one simple reason. They will say, we are not deciding, we are simply executing. There is another body deciding, and that's the Council of Ministers. They have given us an order. This is the objective, and the operation within this support has taken place is the Operation Sophia, operation which now has been replaced by another one, Operation Irini. And so the Council actually is the, if I may call it, the agent provocateur, the body that has actually initiated this supportive scheme. My research on this issue, and it is quite an extensive research because I have studied what the EU has given in terms of money in tackling the migration problem, as seen by the European Union. For me, it's not, it's just a money show, money given without actually being accounted for its achievements. And these achievements, as you all have seen, are not so impressive, at least so far. Well, in that case, I would like to point out that you should focus on the Council's responsibility. But if you go to the Council responsibility, then you touch upon another delicate issue. Council is comprised by ministers representing member states. So you have to talk about state responsibility, not the Commission responsibility. The Commission is just an executive body in the EU context. So maybe you should focus your attention on that. And focusing on that, then we come to your original idea about acknowledging the state's responsibility for a widespread systematic attack on humanity, and humanity being interpreted not just a threat against life, but also a threat against the right to seek a better way of life, something that you have analyzed extensively in your workings. This is something that takes us to a somehow not dangerous, but at least unconventional approach of criminal law. Typically, international criminal law and criminal law is being interpreted narrowly. Here we make a wide interpretation, wider, not a wide, but a wider interpretation of this concept. So if you have to point out specific persons responsible for this crime against humanity, then you have to substantiate the responsibility, tracing the responsibility, as Professor Miller exactly said, that has to be traced, linking the dots, and establishing a causal link between the decision and the resulting situation. And that is and this situation has to be seen through the specter of attacking systematically or widespreadly against humanity. That is an issue that has to be taken into account, I believe, quite carefully, at least in these cases. A final remark on this is that perhaps you may compare the requirements for bringing an action before the European Court of Human Rights regarding the responsibility of the state and the requirements bringing an action before the International Court of the International Criminal Court, which does not apply, again, I believe, against states, but against individuals. So the requirements are slightly different regarding responsibility and establishing this responsibility, because the one is about criminal responsibility, which is much more, let's say, demanding in establishing it, rather than the European Court of Human Rights requirements, which are more plausible, not plausible, more achievable, if I may use this term. These are my remarks that I would like to hand out, and thank you once again for a very informative and very interesting presentation.
Great, thank you, Professor Skiadas. Professor Kalpouzos, would you like to start addressing these questions, or meanwhile I wanted to invite the persons in the audience to send their questions through the Q&A function here. Our students again, the International Law Society students, have arranged for a later meeting. The Zoom link is in the chat, at the beginning of the chat, but it would be great to hear also from you here. So please, Professor Kalpouzos, I have my questions, but I will postpone them.
So I'll try to be as quick as I can, because the questions were so rich and, you know, extended from doctrinal questions to theoretical questions to political questions, and you know, I need another talk to address them. So I can start with perhaps more the doctrinal questions, and so as it happens, your first point on the exhaustion of local remedies is, yeah, indeed, that is kind of I think that the first reaction, right, that a lot of people have in relation to this case. As it happens, counterintuitively, it's not the most complex issue. Why? Because there are two specific provisions that have been developed in the jurisprudence of the European Court of Human Rights. One having to do with time, and the other one having to do with capacity. Right. So to the extent that in order to address the specific matter that we are addressing, you would need to address not only one, but all courts, right? This would require a significant amount of time. And the argument, I think, is a plausible argument to say that the urgency of the situation does not allow that. And in fact, the balance, and I think that's an important point here, that the balance between the domestic and the international or regional in this case is flipped, in the sense that it is the European Court of Human Rights which is asked to act in order to mobilize, activate domestic actors and domestic jurisdictions in order to achieve the urgency of this particular case. And the second point is that applicants are only required to address and exhaust domestic remedies if they can, practically. And one aspect has to do with means, as in material means, money, right, capacity. And our applicants are, you know, those Portuguese claimants, and they do not have the means to address all 33 states. So, you know, it's not a particularly kind of deep theoretical answer that I have to your question, but it is, you know, a very specific application. So it's more, I think, and of course we expect the states to bring those questions, and we are curious to see how the court will address them. But our arguments, or our doctrinal arguments, are relatively straightforward at this stage. It's more I think the shared responsibility questions and the fair share determination that, if you will, we're a little bit more worried about, right? In the sense of seeing where the court will go. In terms of the EU, Libya, and to some extent, you could also say, you know, I mean, let's not open a huge box, but EU-Turkey kind of relationship is so complex. And it's very much a question of Russian dolls in terms of responsibility. And I think you really kind of showed how that works in practice, where there is the European states and the organs of the European Union, and there's to some extent a mutual deferral of responsibility in terms of who has the upper hand. And I would add to this, of course, the role and the function of specialized agencies like Frontex in this context, right, which is especially relevant in the Eastern Mediterranean in this context. So, and the avenue, both the institution, but also the legal issues that you address, are trying to tackle this in different ways. The EU Court of Auditors action is a question of primarily identifying whether the money is properly, you know, earmarked for development aid, or it's doing something else and it's leading to particular violations at that level. The European Court of Human Rights aspect is trying to establish a little bit along the lines of how you said, the question of responsibility in the relation and the balance between Italy and the Libyan Coast Guard in this issue. International criminal law with respect to the Central Mediterranean or indeed the Eastern Mediterranean, we haven't yet engaged. We were engaged at some point into looking in this particular issue. A partner, a set of lawyers and organizations did submit something, but we did not. That's partly because, yeah, it is a complex set of arguments in terms of establishing, in this case, potentially accessorial liability in this instance, right? Interestingly, by the way, the ICC prosecutor has said that she will be looking, or she has been looking into potential crimes committed in Libya, but hasn't named any potential perpetrators coming from the global north, perhaps unsurprisingly in this context. And fundamentally, yes, I agree. It is a challenge of articulating both causality and responsibility and culpability links that are far removed, right, from the effects on the ground. And to use this as a bridge to Zina's points, this is a reductive, right, application. And when it comes to international criminal law, yes, one about which I am very ambivalent, and also one about which I should say there are disagreements, right, within the organizations. Some take a more positive view towards the potential of international criminal law, and some of us take a less sort of positive view of the potential of international criminal law. And so for me, it is a very kind of precarious balance, which is that, and it's almost a balance that is not really designed to work in our favor, which is that international criminal law in some ways might be seen as useful and important only to the extent to which it fails, right? Because it might help with the expressive articulation of the norms and the lines of responsibility, not necessarily in extending, but in perhaps trying to shift, right, our understanding of these rules and these types of liability. But to the extent that international criminal law fundamentally depends on asymmetries of power, if and when it succeeds, it means that, something in some ways has gone wrong, paradoxically, right? I really like, I can't do justice to all of your points because there's 10 minutes to 6 and I want to allow more questions, but just to say that I really like the idea of scaffolding, and I want to think about the idea of scaffolding as a picture, right? A way of, addressing some of the other ideas that you are discussing, right? The idea of, structuring and guiding the interactions with local actors. And our interactions have been varied. In some cases, they have been at the level of claimant. In some cases, they have been at the level of local NGOs. In some level, they have been at the level of sort of broad organizations. So in our Western Sahara work, for example, we have also interacted at some level with Polisario, which is a sort of almost a state-like kind of actor. It depends, as you would imagine. It depends. The type of priorities, approaches that these organizations have will depend. And the idea of scaffolding, I think, is important because, going to the work on evidence and an open source investigation, sometimes when you think about this, it feels that you are making the initial steps towards building something that could go either way, and that has a lot of things that are wrong with it and potentially some things that are right with it, right? And this perhaps speaks, I guess, if I can link it to a broader thing, to the limits of doing transnational litigation in Europe or elsewhere, which are always necessarily limits of distance. And if you forget that even for a second, I think you've lost the game in this context. But as I said, I could speak. Yeah, I have them here, so I'll look at them in detail. So but yeah, if there are questions from the audience, that would also be wonderful.
I think that the students are keeping their questions from when they have you for themselves. I will ask a quick question about the interaction between what you guys do and the general political movement around immigration and the rejection of migration by populist movements, in particular in Italy. I was wondering, when you work on the on the idea that the Court of Auditors might tell us that money which is set aside, earmarked for development, is in fact used for reasons that are not development, because they end up in detention camps on the coast of Libya, which are hard to conceive of as development, right? So that's a very creative idea. I actually love that. But once you let's say you out, or perhaps you kind of raise the issue that the money is not spent according to what the law would have it spent, what kind of movement do you trigger? In other words, politically, if your audience is the anti-immigration sentiment in Italy, right? So if that's what you're trying to tackle there, how do we move from there? And it's a genuine question, because I'm really worried about what's happening there. How do you go from establishing that the money was ill spent, and that in fact that money was spent for things that have to do with security, right, with protecting the borders? Politically, what does that do? That's exactly the political force that is preventing Italy from doing anything more powerful for the migrants, having a more accepting demeanor towards Mediterranean migration. So I like the idea that you guys turn all the stones that you can turn. Okay? I love it. It's incredibly creative and very powerful. But then the game is even more open than it was before. And how do you connect it with the political environment? Do you think about that or not?
Yeah, that is a hard question, Daniela. So thank you for this one. Yeah, so I agree, and increasingly there is thinking and writing about the shift, both in terms of public opinion, but also in terms of institutions, right? There's also some studies that are developing in terms of the shift of the European Court of Human Rights and of institutions at that level, which can no longer be counted on to be progressive in that respect. And I like your point that, if you knock something down, you're opening the field of contestation perhaps more radically, and that radical contestation can go in either direction. And the practice so far, and the evolution of the practice so far, is not really source of great optimism in that respect. So to answer your question, do we think about this? Yes, we think about this a lot. Do we have an answer for this? I don't know that we do have an answer for this. I would lie if I said that we do have an answer for this. One level of addressing this is indeed in the partnership with local organizations. We are continuing to discuss both with Italian organizations and also Greek organizations in some of these elements. And frankly, the evolution of anti-migrant policies has been so comprehensive that it's quite difficult to isolate and study, right, the factors that are contributing to the evolution of where things have been going so far. Which is not to say that if you can't really know exactly why things are going, that you should try just anything you can, right? But in respect to what you said, I think that the exposition or articulation or argument that what is called development, in fact, is not development, is itself a political statement, right? Is an argument which is addressed both to the European Union and to the relevant states, right? That what you want to call soft type of help, development, humanitarian, and so on and so forth, it's quite clearly part of a security policy that has the specific goals, right? And if that opens up the debate, and if that allows certain people to say, good, then let's do that, it may be that this is what needs to be done in this context. But yeah, I do not have ultimately the answer on whether we are opening up forces that we cannot contain. You're muted.
Daniela, we do not hear you.
Sorry. I wanted to say thank you, Ioannis.
Could I add something to what Ioannis just said?
Please.
The fact that you address the European Court of Auditors gives you an edge, a novel edge, because it is the report of the European Court of Auditors which identify not just the legality or regularity of the expenditure, which are, okay, some technical concepts, but also the effectiveness. And this is a concept upon which another institution, which is very keen on supporting the case of the immigrants, the European Parliament, focuses on. So if you establish through the European Court of Auditors that the money has not been spent effectively, and not just whether they have been spent in accordance with the legal provisions establishing the various programs support for this financial support, that could stir up a conversation, a discussion, a political discussion, a public debate, not just within the European institution, but also within Europe as a total, on what is actually happening. And I believe that was what Daniela was concerned more about in her worries. Also in Italy, also in Greece, we have similar issues. In Spain, I believe there are similar issues. In France, there are similar issues. So I think that starting up such a debate would be beneficial for both migrants and the states themselves.
So glad to hear that.
So I think that's a very novel approach.
This is, I think, a perfect place to wrap and thank everybody and let Ioannis drink a sip of water before he faces another crowd. This was great. I am deeply, deeply thankful. When we started a series on structures of inequality, we were hoping precisely for this kind of engagement. To be continued. Thanks, everybody. I'll be in touch.
Thank
Bye-bye.
you very much. Thank you very much, everybody.
Thank you very much.